Hello everyone, welcome to another episode of Live Law where we break down complex legal issues in simple terms and explain why they matter to you. I'm your host Shambhavi and today we are tackling an issue that affects millions of people worldwide, labor rights and laws. This video will focus on recent labor issues including the protest at Samsung and Foxconn and the tragic death of an EY employee that shook the corporate world. We'll not only explain these incidents but also dive deep into the legal framework that is supposed to protect workers. We'll discuss who qualifies as a workman, the Workmen's Compensation Act, retrenchment and layoffs, the Industrial Disputes Act, labor forums for dispute resolution, recent international legislations in the UK and Australia. We'll also look at some interesting case studies and reflect on what these laws mean for workers in the real world. Let's get started. Let's begin by setting the stage. Samsung and Foxconn, two of the world's largest manufacturers, have faced major backlash from their workers. At Samsung, workers protested against low wages, long hours, and unsafe working conditions. Foxconn, which manufactures for companies like Apple, also saw massive unrest over poor living conditions in company dormitories, unfair treatment, and exploitative contracts. These protests weren't just about salaries, they were about human dignity. The latest Samsung workers' protest began on September 9, 2024 at the company's Sriperumbudur plant near Chennai, involving over 1,100 employees. The workers were demanding wage hikes and improved benefits. Despite the company's warnings that strikes risked losing their jobs, the protest intensified, leading to the detention of over 900 workers on October 1st, who were later released. On the corporate side, the tragic case of an EY employee's death due to overwork caught national attention. Reports of this young professional dying due to excessive workplace stress prompted an outcry over the dangerous levels of pressure in corporate environments. This incident has sparked conversations around mental health, workplace stress, and the lack of proper safeguards in companies. Under Indian law, the definition of workman plays a crucial role in determining who is covered by labor protections. According to the Industrial Disputes Act 1947, a workman is anyone employed in an industry to do manual, unskilled, skilled, and technical or clerical work. This definition excludes employees in managerial and administrative roles. Now, why is this important? Because the vast majority of workers at Samsung and Foxconn fall under this category. This means they are entitled to legal protections, including the right to protest and seek legal recourse in cases of unjust treatment, retrenchment, or unsafe working conditions. In this case, the Supreme Court held that when determining if someone is a workman, the dominant purpose of their employment must be considered. The court said that if an employee performs multifarious duties, the primary or basic duties should be the determining factor. Even if an employee is asked to do additional work not in line with their primary duties, this does not change their status as a workman. In simpler terms, the court clarified that it's the main job role that matters when deciding if someone is a workman and not any extra task they may be asked to perform. The Industrial Disputes Act 1947 is one of the most important laws in India when it comes to labor rights. This act governs the relationship between employers and workers, focusing on how disputes are handled, retrenchment procedures, and the rights of workers to strike and protest. Let's understand the key provisions. Right to strike. Workers have the legal right to strike if their demands for better wages, working conditions, or benefits are not met. However, strikes must follow legal procedures. Illegal strikes can lead to job loss or legal penalties. Retrenchment. Section 25F of the ID Act states that before retrenching any worker, the employer must provide 1 month's notice and offer compensation equal to 15 days average pay for each completed year of service. The Foxconn protests have been an ongoing issue at the company's Zhengzhou plant in China, which is the world's largest iPhone manufacturing facility. These protests escalated significantly in late 2022 due to a combination of strict COVID-19 restrictions and concerns about working conditions. In November 2022, workers protested against Foxconn's harsh closed-loop COVID-19 policies that required employees to live on-site with little interaction with the outside world. These conditions led to concerns over food shortages and inadequate COVID protections, sparking large-scale protests. Videos from the protest showed workers clashing with security forces, with many expressing fears of catching COVID due to overcrowded dormitories. The protests were also fueled by Foxconn delaying promised bonuses and benefits, leading to frustration among employees. Workers reported dissatisfaction with the company's failure to provide clear communication about bonuses, leading some employees to accuse Foxconn of unfair treatment. In the Foxconn case, many workers faced arbitrary retrenchment without proper compensation. Reports indicated that workers were forced into unfair contracts, and those who don't comply were terminated without receiving their legally mandated benefits. This is a violation of Section 25F, which makes it illegal for companies to fire workers without following proper retrenchment procedures. While the law provides safeguards, labor exploitation continues, especially in manufacturing sectors where workers may lack knowledge of their rights or fear retaliation. The Workmen's Compensation Act 1923 is another important law that provides financial relief to workers who suffer injuries or death during the course of employment. This act mandates employers to compensate workers who were injured or become disabled due to accidents at work. Let's understand the key provisions. Employers are legally obligated to compensate for work-related injuries or death. Compensation is calculated based on the nature of the injury and the worker's wage. However, this law was drafted at a time when mental health issues were not as widely recognized. The AY employee death incident shines a spotlight on how outdated these laws are. Workplace stress and mental health conditions should be considered work-related hazards, but the current law doesn't fully account for psychological harm. This tragic death highlights a loophole in the current compensation framework. Unlike physical injuries, deaths caused by workplace stress and overwork are harder to quantify under Indian labor laws, leaving the family of the deceased without adequate compensation. Now, retrenchment is a growing issue in India. Retrenchment, or the termination of employees due to reasons like downsizing or closure, mostly economical, has been on the rise in India, especially in manufacturing and IT sectors. Companies like Samsung have often used retrenchment as a tool to downsize without paying workers their full compensation. Section 25N of the ID Act deals with the retrenchment in industrial establishments that employ 100 or more workers. This requires companies to get government approval before such retrenchments. Many of the Samsung workers protesting claimed that they were being retrenched without notice, severance pay or compensation. These actions violate the legal standards set under the ID Act. Just so you don't get confused, Sections 25F and 25N of the Industrial Disputes Act 1947 both deal with the procedure for retrenchment of workers, but they apply in different situations and have some key differences. 25F applies to any establishment regardless of the number of workers employed, whereas Section 25N applies only to industrial establishments that employ 100 or more workers. 25F requires 1 month's notice of pay, 25N requires 3 months' notice of pay. 25F does not require prior permission from the government, whereas 25N requires prior government approval for retrenchment. Coming to another case. A famous case of illegal retrenchment is the collapse of Jet Airways in 2019. Thousands of workers were laid off overnight, and many of them had to turn to the labor court for their rightful severance pay and benefits. This case highlights the real-time impact of retrenchment on families, many of whom are left financially devastated. See, labor laws aren't enough if workers don't have access to justice. India has several forums designed to handle labor disputes. Like labor courts, these courts handle disputes related to wrongful terminations, unfair labor practices, and wage disputes. Industrial tribunals deal with larger disputes, including those involving multiple workers or wage revisions. And national tribunals are for cases that affect industries across states, such as nationwide strikes or large-scale retrenchments. In comparison, let's take a look at how labour laws are evolving internationally. Both the UK and Australia have introduced significant reforms to strengthen workers' rights. In UK, recent amendments in the Employment Rights Act now proposes to cover gig workers, a category that was often excluded from traditional labour protections. So gig workers are individuals who perform short-term, flexible or freelance jobs, often referred to as gigs, instead of working as full-time employees for a single employer. They typically work on a project-by-project basis or are hired for specific tasks rather than being employed under long-term contracts. For example, Uber, Ola, Zomato or Swiggy. Freelancers in creative or technical fields, for example, writing, graphic designing, and even software development. The UK has also strengthened workplace mental health policies, requiring employers to provide psychological support to workers facing burnout. Moving ahead, let's talk about right to switch off. The government has said it will introduce the right to disconnect to promote healthier working practices. Looking to more flexible European models for inspiration, it plans to give workers and employers the opportunity to collaborate on the development of policies or contractual terms that benefit both the parties. Bereavement leave is a type of leave granted to an employee when a close family member or loved one passes away. It allows the employee to take time off work to grieve, make funeral arrangements, and handle any other personal matters related to the death. Many employers have a policy of compassionate leave already. The government wants to make this a statutory entitlement. The Fair Work Legislation Amendment Act 2024 received royal assent on February 26, 2024 and is set to bring significant changes to the employment landscape in Australia. Some provisions are already in effect, while others are scheduled to roll out in the coming months and years. Let's quickly cover the key upcoming changes. Right to disconnect. Effective since August 26, 2024, this right is implemented for non-small business employers, ensuring that employees can disconnect from work outside of their designated hours. Changes to the definitions of employee, employer, and casual employee also took effect on the same date. Importantly, casual employees will have the option to transition to permanent employment through a new employee choice process. Finally, the right to disconnect will extend to small business employers on August 26, 2025, promoting a healthier work-life balance for all employees across various sectors. In 2023, Australia introduced strict penalties for wage theft, a growing concern in the country. So, wage theft refers to the unlawful practice of employers failing to pay workers the full wages they are entitled to receive. This can manifest in various ways, including underpayment, withholding overtime pay, or illegal deductions. Additionally, the government has imposed limitations on work hours to combat overwork and burnout, an issue that mirrors the EY case in India. There is a pending case in the Supreme Court of India involving gig workers. In 2021, the Indian Federation of App-Based Transport Workers, IFAT, filed a public interest litigation seeking recognition of gig and platform workers as unorganized workers under the law. This recognition would allow gig workers from platforms like Uber, Ola, Swiggy, and Zomato to access social security benefits, including healthcare, accident insurance, and minimum wages. The petition highlights that the lack of social security for these workers violates their fundamental rights under Article 14, right to equality, and 21, right to life of the Constitution. The case argues for better protections and regulation for gig workers, pointing out that the Social Security Code of 2020, which recognizes gig workers, provides insufficient coverage and excludes them from important labor laws like the Industrial Relations Code and the Wage Code. This petition is critical as it could influence future policies around gig work in India, especially regarding their employment status and social security benefits. Indian labor laws have often been criticized for their inadequacies, particularly in addressing the demands of the post-information technology era, which emphasizes work-life balance and flexible working hours. With the rapid growth of the IT sector and a shift towards the gig economy, traditional labor frameworks seem outdated. Let's talk about some key points here. The Factories Act 1948 and other labor laws that regulate working hours were designed for traditional manufacturing setups. These laws enforce an 8-hour workday and overtime provisions that do not necessarily align with the flexible nature of IT and knowledge-based industries. The rise of telecommuting, project-based work, and global collaborations necessitates flexible working schedules, which these laws do not accommodate. Indian labor laws do not provide for a comprehensive framework that addresses work-life balance, especially in sectors like IT and services. Research highlights that extended working hours without proper compensation and the expectation of being available beyond regular working hours due to global time zone differences lead to burnout and health issues. This disconnect between statutory working hours and the modern always-on work culture points to a significant gap in the law. As more companies embrace hybrid and remote work models, there is an urgent need for legislation that protects the rights of workers in such setups. Issues like data privacy, compensation for overtime and remote work, and mental health support are often neglected in Indian labor laws, leaving workers vulnerable to exploitation. In contrast, several countries such as those in the European Union have adopted laws that mandate the right to disconnect, which gives employees the right not to engage in work-related communications outside of regular working hours, as I've already mentioned. Studies show that the lack of work-life balance has severe health impacts, including increased stress, anxiety, and heart-related illnesses. The ILO's Working Hours and Work-Life Balance Around the World report notes that long working hours are associated with a higher risk of premature death and mental health challenges. Indian labor laws in their current form do not provide adequate protection against these risks. While Indian labor laws provide basic protections, they are insufficient for addressing the needs of workers in the information technology age, particularly in ensuring work-life balance, protecting gig workers, and regulating flexible working arrangements. Policymakers must urgently reform these laws to align with the demands of modern labor practices, keeping workers' health, productivity, and well-being at the forefront. Finally, let's not forget that these aren't just legal battles. They are human stories. The workers at Foxconn, Samsung, and even white-collar employees like the ones at EY are fighting for their right to live and work in dignity. It's essential that we continue to improve and enforce labor laws to protect the backbone of our economy, the workers. Labor laws are supposed to ensure fair treatment for workers, but as we have seen, many challenges remain. Whether it's the manufacturing sector or the corporate world, workers often face an uphill battle for their rights. These are issues that need both strong legal frameworks and active enforcement to ensure a fair and just society. If you found this video helpful, don't forget to like, share, and subscribe. Let's keep the conversation going in the comment section. What are your thoughts on India's labor laws? And I'll see you in the next video.